name is Anita Earls. I'm an Associate Justice of the North Carolina Supreme Court, and I am fortunate to co-chair, along with Attorney General Josh Stein, the Governor's Task Force on Racial Equity and Criminal Justice. And you are here with us for the very first learning session on race, data, and policing. So just a quick word about the task force. It was established roughly a year ago by the governor. The first 6 months we spent examining what recommendations we would have to advance racial equity in the criminal justice system. The following 2 years until December of 2022, our task is really to seek implementation of those recommendations. You can find out everything about all of our meetings, past, present, and future, on the TREC website, which is www.ncdoj.gov/TREC, including upcoming events. We are in July hosting a series of technical sessions on how to use the American Rescue Plan funds to implement some of the TREC recommendations at the local level. So I hope that'll be of interest to people. But to the topic today, our first learning session on race, data, and policing, our goal is really to provide information to you, to receive your feedback and comments. So we hope that you'll be very active participants. And third goal, to explore whether there may be additional policies or practices beyond those in our original December set of recommendations to the governor that might be useful or necessary to address the problem of racial inequities in the criminal justice system. And for this topic today, I'm going to introduce our moderator, and she'll let you know about the panel. We are extraordinarily fortunate to have exactly the right person to be leading this discussion. Professor April Dawson is the Associate Dean of Technology and Innovation and Professor of Law at North Carolina Central University School of Law. She received her undergraduate degree in computer science and was a computer programmer before attending law school. Professor Dawson currently teaches in the areas of constitutional law and technology, and she's a member of our task force. I know, because I've talked to her students, that she has a reputation at the law school for being an incredible mentor, as well as her role in the community hosting Legal Eagles radio show. We are just so fortunate to have Professor Dawson, and I will turn it over to you.
Thank you so much, Justice Earls. I appreciate that introduction. And thank you to all of you who are joining us tonight for this incredibly important discussion about the use of data and predictive analytics in the criminal legal space. So first, let me share with you a little bit about the format of the program. So I'm going to, after sharing kind of the logistics, I'm going to give some general remarks and provide just a little bit of background to frame the discussion. I will then introduce our panelists, and they will give brief opening remarks. I will then, as moderator, ask them some questions and have them share more of their insights on issues and hopefully some suggestions related to the use of predictive analytics. I will then have our audience submit questions. And so if you are on this Zoom call, you can submit questions in the chat. And if you are watching this via YouTube, you can actually put your questions in the comments section. And so with that, let me just say a few things before I introduce our wonderful panelists. So as we know, technology is impacting all aspects of society. Not only do we use technology devices throughout our daily lives, private companies use big data, algorithms, machine learning to predict what we will buy, what television shows we will watch, and even how we might cast our ballots. Governmental agencies and organizations have also embraced the use of big data and predictive analytics. While there can be benefits from the use of data in making governmental decisions, we as a society have to be cautious of unintended negative consequences that can result from the uninformed use of algorithmic predictions. One of the major areas of concern is the use of prediction models by law enforcement and other criminal legal system units and organizations. While the use of data may appear at first blush to be unbiased and objective, the use of predictive analytics in the criminal legal space can very easily exacerbate the racial discrimination and disparity we already see in the criminal legal system. So during this discussion, we will hear and learn from two experts on problems that are and can occur when big data is used in making life-altering decisions by law enforcement agencies and the courts. We'll also explore how to harness data in a way that improves the safety of our communities without reinforcing disparate outcomes. So with that, let me introduce our panelists. So first we have Brandon L. Garrett, who is the L. Neil Williams Jr. Professor of Law at Duke University School of Law. He is a leading scholar of criminal justice outcomes, evidence, and constitutional rights. Professor Garrett's current research and teaching interests focus on forensic science, eyewitness identification, corporate crime, constitutional rights and habeas corpus, and criminal justice policy. In addition to numerous articles published in leading law journals, he is the author of 5 books related to criminal justice reform. We also have Arvind Krishnamurthy, who is currently a PhD candidate in political science at Duke University. His research focuses on the politics of criminal justice in America, using causal inference methods to study how institutional design affects racial inequality in criminal justice outcomes. He is the co-author of the Oxford University Press book, Deadly Justice, a statistical portrait of the death penalty. And his research has also appeared in the Duke Journal of Constitutional Law and Public Policy and the Wake Forest Law Review. I want to thank you both on behalf of myself, on behalf of the entire task force and our audience tonight for taking time and sharing and educating us. So right now we'll have each of you give some short opening remarks, and Professor Garrett, we will start with you.
Great, thank you so much. Thank you so much, April, for that introduction. It's great to be here with you and with Arvind. I'll keep this very short. I'm really looking forward to all of your reactions. And so there are a lot of different ways, and as the agenda for this program makes clear, that law enforcement agencies rely on data and analytics. Everywhere in our lives, data is being collected about us, analytics are being used based on our information or to inform our shopping decisions or any other number of different things. And obviously, if we understand that we're being recommended movies based on the movies we've watched in the past, and we know that that might not be exactly what we want to watch tonight, that's okay if it's transparent to us and we made the choice that we're kind of interested in what the recommendation might be. Very different, obviously, in the world of criminal legal enforcement, where people may not consent to having their data shared or used, and where the public may not know how data is being used or how algorithms are being used. Or also troubling, law enforcement agencies themselves may not know what's inside the black box of the algorithm that they're relying on to some extent. It's a perfect day to be talking about this. For those of you law nerds, the Fourth Circuit Court of Appeals just struck down an airborne surveillance program in Baltimore, which was litigated for some time, where real-time photographs were being taken all over the city, and the court emphasized that this is a serious Fourth Amendment violation of people's privacy rights, that enough photos are being taken across the town that people's locations can be tracked, lots of personal information can be digested, given the comprehensive nature of what was being collected. That was a program by a particular police department. Any number of police agencies may or may not, it's not typically disclosed, be using all manner of different surveillance, whether it's erecting fake cell phone towers that pick up signals from phones, license plate readers, facial recognition technology. If you have a North Carolina driver's license, your face is in the federal face database, and it's being searched every day and being compared to images potentially from crime scenes. We know that some law enforcement agencies have joined that federal face database, and we know that it is of unknown reliability. That it's been represented that, well, we haven't tested it to see whether there are false positives or false negatives. It's only being used to generate leads, and so we don't need to know how reliable it is. That's sort of been the position. But if agencies are using our faces without our consent in ways that we don't know whether they are reliable or not, that should be of grave concern. In other areas of forensics, algorithms and data are used. Forensic databases run searches on fingerprints, firearms evidence. Sometimes it's supplemented by a human examiner who then looks at the fingerprints that the database turns up and decides whether they think that they are a match. Lots of issues with human decision makers relying on their own sort of match criteria to link forensic evidence. But these databases are often based on algorithms that are proprietary and that the crime lab themselves don't know or understand how they work. In the same way with predictive policing, we're on the one hand worried about officers relying on their discretion, which can be heavily infected by race to make all sorts of decisions. For example, we've known for years that traffic stops in North Carolina exhibit enormous race disparities. Maybe it would be good if officers relied on more objective criteria to decide who to stop. But that said, we don't want them relying on algorithms that bake in discrimination or that are of unknown origin or reliability. There is no requirement that agencies, disclose what types of predictive measures or algorithms they are relying on. In other cities where it's come to light that predictive policing has been used, there have been investigations, and some of those agencies have decided to stop using the algorithms. There are other types of databases that law enforcement have used. There is a school gang database in North Carolina where kids can be placed, under extra supervision or have an extra consequence because they appear on social media wearing like a gang color, like blue. And as someone who goes to a university that adopts a certain shade of blue, like I would be very worried about one of my kids wearing a shade of blue and being put in a gang database or making a symbol or something like that, maybe as a joke, and all of a sudden ending up in this non-public database. There are also quite positive uses of data that could improve the use of discretion or improve outcomes. There has been lots of debate about the use of risk assessments pre-trial. In some situations, they've been used to supplement the discretion of judges and result in many more people being released who otherwise would have been held on cash bond. There are also concerns about proprietary, non-public, and quite concerning pretrial algorithms, which might unfairly lead people to be held in jail. And so it's important to vet these types of tools when they are used. There are efforts to replace the human discretion of like the fingerprint examiner or the firearms examiner with something that would be more accurate and impartial, which could be a good thing if it's vetted and approved. What some states have done is there have been some laws passed just this last year that if you want to use cell phone tower surveillance or the like, you have to get a warrant. If you want to use predictive policing, you have to make it public, you have to vet it. There have been efforts to introduce algorithmic fairness acts so that if any law enforcement agency is using any kind of algorithm, it has to be public what they're using, and independent researchers need to be able to examine it and know what they're doing with it. And I suspect that many more states will start looking at these things more carefully, including just to uncover, well, what are agencies using and how? And then what do we do about it in terms of what we approve and what we disapprove as members of the public? But we certainly don't want government using data tools on citizens without us knowing about it, just in terms of fairness, transparency, and ability of the public to weigh in on what our government is doing. So that's my quick overview and introduction, but I'm really looking forward to everyone's feedback and comments and discussion of this. It's a really important issue that deserves more attention here in North Carolina and in across the country.
Thank you, Brandon Garrett. Arvind Krishnamurthy.
Yeah, thanks, Professor Dawson and Justice Earls for those introductions, and to the task force for putting together, what's a really important conversation. So I'm excited to speak with you all and also be in conversation with a great thinker like Professor Garrett. So with that, I think my comments will kind of touch on two ways that the research and literature I work in looks at predictive policing. And so with both of these, I'll issue a word of caution, but that's not to say that I don't think there are important ways that data can be used in these contexts. I think it's just really important for us to be careful to treat them data and predictive tools as the solution in and of itself to what are really difficult problems. And so the first thing is I'll use a phrase or law that is often invoked by people who work with data in this area, and it's something called Goodhart's law. And what Goodhart's law says is that when a measure becomes a target, it ceases to be useful as a good measure. And so when we think about the way that one of the main ways that predictive analytics are used in policing, we can think about the way that metrics are used to evaluate officers' behavior and to hold officers accountable. And so we can think about a program like CompStat that was most famously used in New York, but spread all across the country. And research from scholars like Laurel Eckhouse at the University of Denver has shown that the implementation of CompStat, which is used to evaluate, it's a computational program used to evaluate the quality of policing, among other things. Following that implementation, there was an increase in minor offense arrests, and there was also a change in the way that police officers were clearing or finishing off investigations related to more serious crimes like sexual assault, where they would increase the rates of labeling these as unfounded, because they knew that metrics like clearance rates and arrest rates were going to be central to how they were evaluated. And like kind of Goodhart's law is saying, you're going to have a problem where when you're relying very heavily or even solely on these measures, they can sometimes cease to be as useful as they were before they were the focus. And the second thing is kind of thinking about the practice of using analytics to efficiently allocate police to maximize the returns on safety. And so with this procedure, you'll often see departments use mapping software like Predpol is an example, and they'll use geocoded crime data to identify things like hotspot locations or high crime locations. And then often the procedure is to send more officers to those areas. Now, one concern with this is kind of like Professor Garrett touched on, this concept of bias in, bias out. So if previously departments are relying on intuition-based policing, and we know that some of these intuition-based procedures generate inequalities, well, when you use these algorithmic procedures, they're getting data from the very process that generated the inequalities. And if you rely on that, you're going to actually, in many times, amplify or at least reinforce those inequalities. And that's a real problem when we think about the fact that crime data, especially when it comes to a lot of low-level offenses, can reflect activity from the police, not just actual law-breaking. And so there's research by Christina Lum and William Isaac that's really useful on this, that use the Predpol algorithm and survey data to show how this problem can have reinforcing returns in Oakland, California. And so those are two sort of ways that I'd say I'd issue caution when we're thinking about this, but I think that doesn't mean that there isn't a role for data and for analytics here, but I think we have to be careful when we're thinking about it as the solution, would sort of be my main takeaway from this.
All right, thank you both. I want to encourage those who are viewing via Zoom or YouTube to go ahead and start putting in your questions as they arise. I've got some questions kind of teed up, so I'm going to take the moderator's privilege and start off. And both of you provided us with examples of where there were these unintended consequences. Can you share why it is that it is so easy for the use of data to result in greater disparity, particularly when we're talking about racial disparity?
I'm happy to jump in quickly on that one. I think one difficulty here is that while oftentimes you'll use models that do not include race explicitly in the model, it's very easy to identify race because of the way society is structured, indirectly through categories like geographic location, income, and so it'll correlate highly with race, and you'll see models oftentimes that that because of this strong correlation will end up essentially reproducing if they had included race in a model explicitly. So that's one thing. And then the other point on that would be basically that it can be very difficult to anticipate sort of strategic action from individuals who are operating under with use of these tools, right? So, like the example I gave in with CompStat, where you, for lack of a better term, you had juking of the stats. It's hard to know beforehand how people will respond to some policy change like that, especially when that policy change has an effect on individuals' futures, right? So they're going to act strategically to try and maximize their own personal interest. Often, it's if you're being promoted based on these metrics, of course you're going to do everything you can to maximize those metrics. That's natural. That's what everyone will do. But that's why we have to think, and especially on the policy side, need to think about what could those consequences be, even if we aren't, even if they might not be the most likely outcome when we're just looking before they're implemented.
Yes, thank you for that. And I think we may have lost Brandon Garrett, technical issues, but I'm sure he will join us just as soon as he can. And so I think one of the things that you hit upon is that there are proxies for race. And so if we think about particular neighborhoods, or we think about particular types of crime that law enforcement is focusing on, that oftentimes we will see racial disparities. In talking about that, and when we think about predictive analytics, so there is a distinction that is sometimes made by law enforcement focusing on the location versus focusing on people. Can you talk a little bit about what that difference is and the advantages and disadvantages of using predictive analytics to focus on maybe hotspots versus particular individuals who are at high risk of maybe becoming involved in the criminal legal system?
Yeah, I think this is a great question. So first off, I think one thing I'd say that is common across both of these is that, and it was touched upon earlier, is that it's difficult sometimes for in a democratic sense the public to be able to hold accountable things like algorithms or model-based or geographic models that are making directives that are being followed, because they're not fully transparent in the same way that you might be able to say, okay, the police commissioner, I can speak to, I can go attend these local community meetings. I can engage in a way to change the implementation of policy if I see something, but it can become a little less straightforward when you're almost trying to change the inputs to a model like PredPol. And so PredPol has been used kind of in both ways, but the main way it's been used is to generate these boxes within cities or neighborhoods where departments might believe that there's a high likelihood of criminal activity there, and they'll choose to send officers to those locations. And that procedure is a little different than some of these models. I know a similar one has been implemented in Chicago, where there are actually lists created of specific individuals whom they believe there's a high likelihood of being at a risk of victimization for crime, or sometimes even offending, but often victimization. And so these generate different outputs, right? One might generate a list of people, while the other might generate specific locations to send officers, but oftentimes they may end up having very similar functional effects, because the people that are being generated by these procedures are often going to be very geographically concentrated, and the outcome might be the same, where you send more officers to a specific neighborhood or community, just like you would have with PredPol.
All right, thank you. And Brandon Garrett, we knew you were having technical difficulties. We knew you'd join us when you can. So thank you.
I'm so sorry.
That's okay. That's okay. Look, in this Zoom environment, we're all very understanding of tech and tech issues. But actually, one of the things that Arvind mentioned was not knowing, and this is something that you touched upon in your opening remarks, not knowing what's behind these algorithms, that they are private, that they are proprietary. Can you talk and share just a little bit more about why it is that they are proprietary and why it can sometimes be difficult for the public to know how these algorithms are working to produce the predictive analytics?
Well, first, they're only proprietary because a company that designs it would prefer not to share what they designed, maybe because they don't want people to know whether it's reliable or not, or maybe just to gain a competitive advantage over other companies trying to sell a similar product. That obviously raises the real constitutional due process issue. So these things may be proprietary until someone actually tests it in court, and it can turn out to be a costly mistake for a police department or a crime lab or whoever it is to rely on something where someone goes to court and says, well, wait a minute, you have evidence that you want to use to try to convict my client and you're not disclosing it? Well, now we need to have independent experts vet this thing because that raises real fairness concerns. This is a criminal case in an open courtroom. You can't be relying on some black box. And so there's been costly litigation over this. And some courts have upheld different forms of commercial privilege. There's been a lot of complicated litigation over it. Other courts have said that we need to disclose these things. And that may not have been what law enforcement agencies bargained for when they thought they were just getting a good deal on an interesting toy. But in criminal cases, people have a right to know what the evidence is that is being supplied against them. In terms of the reason why some of these things may be black box, sometimes there is no good reason, right? There is a human designer who programmed something to rely on certain types of data and inputs, and they could absolutely disclose it if they were required to. In some situations, there may be some kind of a machine learning approach where the machine itself is just sort of like building a system to produce outcomes that the designers were hoping for. And so the designers may be instructing the machine, like, we want to, produce the most hits based on where arrests have happened in the past, or we want to, target the addresses that seem to have gotten the most attention in the past. And so they don't really know what's going on under the hood of the machine. They could, but they choose not to. And there's work done that, you can have explainable machine learning. You can get all the advantages of high-powered machine learning with built-in explanations so people know what's happening and can actually tailor it based on their own priorities. But sometimes it's easier for these designers just to sort of, we'll just let the machine do what it wants with the information, and it's sort of a lazier approach, and it also could be potentially really harmful to people's rights if we're talking about using this to make decisions like whether to stop someone, arrest someone, or charge someone with a crime.
All right, thank you for that. And we've got some questions. I'm going to go ahead and start reading some questions from folks that are putting them in the chat or the YouTube comments. And so here's a question here that says, can either of you drill down into some specific examples in North Carolina on how data is being either not effectively used or misused?
I should also say there's a lot of data that we just don't have in North Carolina, which is a separate problem, right? There might be places where we really could do important things to protect people's rights if we only had data, right? There's legislation being introduced right now that we don't have data on officer use of force in a way that would allow us to know about serious police misconduct across the state. And so, data can bring with it great transparency and really good things. The concern is when data is used in ways that aren't transparent, and that can be harmful. One everyday example is just that some of the forensic algorithms that are used to pull fingerprints or firearms evidence are proprietary. Crime labs can't get access to how good they are. They would like to use the algorithm that they think might pull fingerprints that might be the right ones, but they don't know. And that's a national problem. None of the companies have much incentives to disclose how their product works. I mentioned the face recognition issue, where there's evidence of real error rates in these facial recognition algorithms, but they've never really been tested, including the FBI's own algorithm, where the Office of Inspector General has issued these reports saying, like, if you're doing stuff with images that belong to members of the public, you need to justify the accuracy of it and say something about that, and it hasn't been done. I don't think we know which agencies in North Carolina are using that or other facial recognition tech ever. We don't really know what the scope of the use of that is, or how it's being used, or whether mistakes have occurred or what. So there's that again is part of the transparency problem, is that we don't know what tools law enforcement may be playing with, using, making decisions.
Yeah, just briefly building on that, I think one problem that's present is in general, and not that this isn't happening at all, but when governmental agencies are using algorithms, I think one of the most important questions that needs to be asked is, are you constantly evaluating how effective these policy implementations are? Because it's difficult to paint, I think, with a broad brush across, even just with like judicial decision making in police. You have very different kinds of tools that are used, and they aren't all used in the same way. And I think one thing that can help both the public in terms of transparency and everyone in terms of knowledge building is if these programs are constantly being rigorously evaluated, and so there's transparency about their use and transparency about the outcomes that they expect will change after the implementation of these programs, and then that data is provided. So I think that's one thing I would push for more of.
Mm-hmm. And so a related kind of follow-up question to that is, and this lack of transparency, as both of you have noted, is incredibly problematic. What can the concerned public do to demand transparency? So Arvind, one of the things that you mentioned was, we can ask the question about how often are these algorithms and these systems and these models being evaluated for accuracy? And that's one aspect of it, but you all have hit upon a number of different places and points where we just don't know. Any suggestions on how the public can demand more transparency?
One simple way is for people to ask their local agencies, what are you using? And ask for a complete answer in writing. We haven't done even basic surveys. I assume a government agency might be able to get more complete and accurate responses than people asking here and there in the county in which they live. But that still may not provide the right information about, well, how is this thing being used? How reliable is it? How has it been vetted? And more broadly, we may want to consider rules that regulate and restrict how these different tools are used, so that if they're used for surveillance or searches, well, they get treated like searches, and you need a warrant, you need approval. The state of Maryland just had a really good process. They brought in all sorts of different stakeholders, law enforcement, scientists, innocence projects, passed legislation regulating when familial DNA searches can be used. That's a type of a search that implicates all sorts of privacy issues, but sometimes it can be valuable to law enforcement, and there was no authorization to use it in Maryland any more than in other states. So the idea was, let's carefully think through with all the relevant stakeholders, what are the interests at stake, and actually have a regulation and a process for when you are allowed to do familial DNA searches. So that's a model for a really deliberate, good process to inform legislation on how to regulate a use of it's really database algorithm technology, but one that implicates family privacy, genetic privacy, and other issues. I don't think we've had those kinds of conversations here in North Carolina, and we should. There's been a lot of Maryland today between familial DNA and the Fourth Circuit decision about the airplanes flying over Baltimore. But,
yeah, I think two things I would point to are, one is making sure that if this is something that's important to you, and obviously based on what I do, I think you should think it's important, but is make sure you talk to the politicians and individuals who have some ability to provide oversight, right? So whether that's mayors or city councilors, and if you make clear consistently that this is an issue that's important, and also that the importance of this issue, it requires consistent communication, consistent levels of transparency and evaluation that's made public, that, those are the kinds of, if your democracy is working correctly, that's where you'll see politicians respond and try to make sure that those policies are implemented. So that's sort of the main suggestion I would have, but I think also conversations like this, which help educate and get people thinking about these questions and are supported by governmental agencies, are really important, because they show a commitment and prioritization and are taking steps towards transparency on these issues.
Mm-hmm. All right, here's another question from our audience. What are some of the considerations that inform the choice between algorithmic methods in the criminal justice context, which we have known and mostly quantified, biases, and the state of the art, which is unstructured human judgment with known but largely unquantified biases?
Yeah, I think this is a really great question, because the hard part here is that even if we know that these algorithms or models or any use of sort of data and analytics in the criminal legal space has problems, that doesn't mean that the alternative is without any issue, because in many times it's not obvious which one will generate more favorable outcomes. I think in large part the considerations should be about procedure, like things like is the public able to be able to hold everyone accountable who's involved in this? Is the public able to follow what the process is for decisions like where officers will spend their time, how pretrial detention policies are decided? But I again come back to, this is where it's really important to be constantly evaluating, because only through those evaluations can we really know which approaches are being more or less effective, especially once they've already been implemented.
Yeah, I agree with everything Arpan said. And, we know that all of us as humans are imperfect and can be really biased decision makers, and we don't always have good information. And so sometimes algorithms can be more accurate. The concern is that algorithms can be designed based on information provided by human decision makers. So they can be relying on, the biased decision of police officers in making, low-level arrests. And so they'll just replicate that bias. They'll bake it in. On the back end, there's the concern that, most of the time it's not like an algorithm is actually deciding who goes to jail or who gets arrested, right? It's providing information to a human decision maker that's still going to have discretion to decide whether to follow the advice of the algorithm or not. And so it could be that the human looks at the facial recognition output and says, that doesn't look like the face of the guy in the picture at all. I'm not going to arrest that person. Or that I'm not sure if that's the face of the person who robbed the convenience store. I'm going to actually, talk to the witnesses more, see if there's DNA that can be tested. I'll do a full investigation, and I'm not going to just rely on this algorithm. Or the bail judge could say, the judicial officer at the bail hearing could say, well, maybe this person, according to the algorithm, is high risk. But, I've listened to what the public defender said. This person is now receiving serious treatment for the addiction issues that caused the conduct. I'm happy with the conditions that could be imposed that would result in release. Thank you, algorithm, but there are other factors at play here that make it the right decision to release this person and not jail them. And so, but you could also have, the concern that, we saw this in looking at the use of risk assessment in sentencing in Virginia, that there was racial bias and also just geographic bias in when judges followed the algorithm or not. So in sort of like in sympathetic cases, judges thought, oh, low risk, I'll give this person a lenient sentence. And in other cases, judges would say, oh, low risk, I'm going to ignore that. I'm going to give the person the same harsh sentence. And so we have issues with the human information that's fed into algorithms, and we also have issues with how humans make decisions based on quantitative information. And most people who are lawyers like me, we don't have like a quantitative or statistic background, and we may do things that are really not what the algorithms are even designed to do because we were bad with numbers, or we have our own sort of assumptions and biases.
All right, here's another question. It seems that this tool is used to target only perceived negative aspects of society. How can this be used to target society improvements, such as true equality, poverty, and such?
Yeah, I think this is a great question because one thing I think is always true is when you're talking about criminal justice and the criminal legal system, it's too narrow to focus solely on questions related to what's traditionally considered criminal justice policy, because think social policy more broadly is so fundamentally related to all the questions we've talked about here. And so I think this is a really powerful question because it's reframing things in an interesting way, because when we've talked about some of these algorithms that will do things like indicate areas where there's a high risk of crime or individuals who might be at a high risk of violence, the response to that doesn't always have to be things like increasing police presence. It could be alternative things like increasing investments into those communities, building up community organizations or local nonprofits. There's a lot of great work by a sociologist named Patrick Sharkey that talks about how the rise of nonprofits and community organizations was one of the primary causes of the crime decline of the last 20 years. There are a lot of different ways that we can use some of the outputs that data in general is pointing us towards communities that might need more attention, and thinking about both more broad social policy and community investment, I think, is one of the points I would make there.
And so that I think kind of speaks to this, intervention. Are we using this information to intervene and help to prevent individuals from becoming wrapped up in the system, or just for enforcement purposes? Let's see, another question here. Let's see, do you think unintended consequences are introduced at the academy to new officers or later pushed down from the supervising captains?
I don't know if that's a data question. It seems like more of a police culture question, but there are lots of interesting issues in terms of police training and how does early training translate into what people are told to do once they're on the job. And it's true for us as lawyers too. There are things we learn in law school, and then we start doing work and see how it really is, and hopefully remember some of the lessons we learned in law school. One of the main recommendations, though, going back to the Obama White House's Presidential Council on the 21st century policing, is that just like with lawyers, training doesn't end when you leave law school. Training does not end for police officers. There's a new focus on continuing an experiential training on use of force issues. It's not enough to just sort of say you need to de-escalate and adopt a range of different tactics before resorting to deadly force. You actually have to have experiential training, so it becomes habit for officers to work through those alternatives before they draw a weapon. So police training is really, really important. Not really a data question, different topic, but that said, in really good consent decrees around the country, there has been a data aspect to it to identify these kind of cultural issues where you can have officers or units where use of force incidents are sort of more common, and it may not be deadly force. The vast bulk of interactions between police and the public are obviously not deadly,
but often milder forms of force are used. They're not tracked, and they have what these call these early warning systems to try to detect patterns of misconduct and to provide training or remediation and figure out what's going on with that group of officers. So that is an example of kind of a risk-based approach to try to prevent harm to the public, relying on police data, but also coupled with an understanding of training and culture to try to help policing agencies resolve these problems before anything happens that seriously endangers our lives in the public or officers' lives.
Here's another question. Can you point to any exemplars or good examples of the use of data analytics or algorithmic methods in the criminal justice context?
I guess I was just talking about one. It's not really algorithms, but to really be examining this internal data. Another really good example is, for decades, we've had forensic scientists come into court and say, I've looked at some patterns, I've eyeballed it, and it's a match. And that can be really powerful evidence. People assume that like fingerprint evidence is perfect. It would be much better if we had algorithms that were accurate, that weren't just based on someone's sort of call based on their judgment, or where we don't know how reliable they are. However, it is possible to also do analyses where you test crime labs, where you do auditing. One thing that's done at the Houston Forensic Science Center is that 5% of all their cases are sort of blind tests. And that way they can generate this data and catch mistakes in cases that aren't real ones. And so someone isn't going to be, wrongly convicted based on an error in a fingerprint case or a firearms case. They catch the error with these tests. And they also know if there are particular people in the lab whose judgment isn't as good as their colleagues. That's not done in North Carolina. It should be sort of done at any lab, just like at clinical labs. They have to be doing auditing and proficiency testing, because lives are at stake if you misdiagnose cancer at a clinical lab and the like. Well, we don't have those kind of quality controls at our crime labs, and it's a problem. There have been crises involving our crime labs in North Carolina, the former SBI lab, but the response has not been kind of quality controls that you have in real laboratories at hospitals, or and so I think that same principle that the same way you should be auditing use of force data to look at problems and see whether there are officers that need remediation. I tend to think that real regulation involves collecting data, auditing, and making a more justice system has worked in the past.
Yeah, just building on that, I think an interesting case here in North Carolina, and I'd love to hear from anyone who might know more about this case, is what happened in Fayetteville, where there was a policy change that and I believe this was shortly after a fatal police citizen encounter during a traffic stop, where the Fayetteville Police Department basically said, we're going to reduce the number of stops that we make, traffic stops that we make for non-public safety moving violations. So essentially cutting out a large number of stops for things like equipment failures or like expired registration, things that weren't things like speeding or excessive speeding, and or driving under the influence. And it seems like from the data that I've seen that there was a reduction in fatalities on the road. There was a reduction in the racial disparities of traffic stops, and it doesn't appear to have compromised in any way public safety more broadly. So that's a kind of example of an evaluation. And again, I'd love to hear more on this from anyone who might know, but an evaluation where a department sort of internally looked at what was actually generating the returns that they wanted. They made a policy change based on their own information, and it had really positive impacts on the community as a whole.
So here's probably our last question before we have you all do your closing remarks. What data is available to us by race at the state and local level, and what can we do to get access to this data?
There's
there is data that is collected in terms of criminal court data. And so there's sentencing data that the Sentencing Commission reports on each year, and the aggregate they report race breakdowns. There's much more detailed court data on charges, dismissals, sentences maintained by the Administrative Office of the Courts. I think it's a data file that's available to the public. I think they charge, $16 or something like that if you don't have a thumb drive to bring with you. But that said, it's not a user-friendly format. It takes people with a serious status to know how to work with it to some extent, and it took them a long time. But there are differences in questions about how race is coded. People aren't often asked to sort of self-report race or ethnicity. Often ethnicity isn't reported, and so it's race but not ethnicity. So there are lots of ways that we can be collecting better information that would allow us to better understand race and ethnicity data. I saw in the chat, yes. So traffic stop data has been collected and made public in a really accessible way in North Carolina. Going back to, 1988, 1999, North Carolina was a pioneering state, passing legislation to require that traffic stop data broken down by jurisdiction and race be made available publicly. So that data, we really stand out as a state in having really detailed data made available on that. In terms of court data, it exists in some really useful forms with some limitations, and it's kind of hard to work with.
All right, so we're coming to the end of our time, and I'm going to ask each of you to give closing remarks. And there is this one last question that I think I would invite you to think about as you're sharing your opening remarks or your closing remarks, which is, what's an important takeaway or a summary of takeaways that we as the general public should leave this panel with? And Arvind, let's start with you.
Sure. I think, kind of going off a lot of where this conversation has been, I think it's clear that the use of algorithms and in general how data is implemented in the criminal justice space is not a straightforward procedure of we should be implementing algorithms as a tool to replace human decision making or even expect it as sort of the panacea or solution to many of the problems that we've already encountered in the criminal justice system. I think the main set of takeaways I would say is that first, it's important that the public and in general policymakers should constantly be evaluating the tools that they are implementing. Second, that it's important to consider both the unintended consequences that go along with implementing these policies and also the way that these policies are implemented, the strategic behavior from the actors who are interfacing directly with these algorithms, how that might change things. And then lastly, just thinking about accountability. How do you make sure that there's a procedure to both generate feedback and change and adapt and use sort of the democratic process to evaluate these tools if for some reason they are accelerating inequalities? What's the process for the public to get to have a say in the implementation and continuation of these tools? So those are the main things I would say.
Mm-hmm. And Brandon?
I agree with everything that Arvind said. I think that those priorities could be set out in legislation so that there is an ability for evaluate if there isn't notice of what is actually being used. So there should be a process set out in statute for an agency considering a tool to say, okay, this is what we plan on using. We'd like feedback and a process to evaluate the tool. As like a voter, I have no idea whether an algorithm is accurate or not, and so there should be a process for independent researchers to vet whatever is being used. And there should be, after that review process, the ability to then reach a decision about whether it's appropriate in the way that it's being used. And over time, there should be the ability to assess whether there are disparities and biases, including racial biases, and how the tool is being used. Now, I think we should be doing that for non-algorithmic decision-making too, in the same way that there's the traffic stop website, and we can look at racial biases and how traffic stops are done across North Carolina. Of course, that's also a little bit of a cautionary tale that just having the data out there and being transparent isn't enough, right? That website since the 1999 has shown racial disparities across North Carolina in police traffic stops. And you don't have a lot of Fayetteville stories where jurisdictions decided, you know what, these disparities are uncalled for, they will stop. They, for the most part, are just every year these disparities are documented and the public can see it. So, but that said, some transparency and notice is a good starting place, and then there'll be a lot more work to do.
Mm-hmm. Well, we have reached the end of our time. We just want to thank both of you so much for sharing your insight, providing us with food for thought, educating us. We have here with us Arvind Krishnamurthy. He is a PhD candidate in political science at Duke University, and Brandon Garrett, who is the L. Neil William Jr. Professor of Law at Duke University School of Law. And I want to encourage those of you who are participating or attending this webinar to be on the lookout for other Trek Learning Series sessions. So we plan on, this is just the first of hopefully many. We want to thank you all for your time, and thank you for those that really helped to organize and put this panel discussion together.